Societies, as they evolve, lay down rules for their organization. In looking for inspiration, the ancients often turned to the realm of the supernatural, the divine. The divine socio-religious order that these rules came to establish very often turned patriarchal.
They were looked upon as subhuman, and therefore they had no right, it states categorically that the woman had no right over her own body or over any money or any earnings.
Modern societies have laid down the rules for their governance in their constitutions. Depending on the form they take, constitutions perpetuate the rule of individuals or of the law. The rule of law, however, operates within the bounds of the religious and the cultural traditions of the land. So strong is their hold that neither the socio-religious reformers nor the founders of our constitution were able to completely break free of them.
The ingrained patriarchal attitude of looking down upon the woman, ignoring her as far as possible, taking her as a subhuman being, that still persists in most of the households. But Constitution changed a lot of what was anti-women.
The mandate of equality that the Constitution gave to the women was an acknowledgement of their role in the freedom struggle.
That our Constitution was worked out of the experience of the independence struggle, in which women participated in large numbers and suffered and sacrificed equally with men.
The lawmakers were presented with an opportunity to break free of the centuries-old biases against women. However, as the Constituent Assembly, the body that formulated these laws, settled down to the nitty-gritties, other realities began to dawn.
When we discussed the role of women, there were some who said they had equal rights, but when it came down to brass tacks, one found they were not so equal.
If at the one end of the spectrum this meant the partition, then at the other end it meant the inability of the Constitution to bind the nation under a common civil code.
It could not be put as a fundamental right. Common civil code, uniform civil code could not be put into fundamental right.
For the women, this meant that complete equality was still a distant dream, a dream that eludes them even after 50 years of independence.
In fact, if a woman wants to challenge a personal law on the grounds that it violates a basic fundamental right of the Constitution, she cannot do it. So I don't think women have really been granted equal rights.
The law of the land has given us one criminal law, one law of contract, but has kept us divided in the most important area of our life, our family.
Civil Procedure Code, Criminal Procedure Code, Contract Act, Transfer of Property Act, Land Reforms Act, all these acts we have common law. But in respect of family laws or personal laws, we have different laws for different religions.
To be fair, independent India did attempt to set some of these imbalances right.
For instance, if the Hindu Code Bill hadn't been revised, someone like me who's an only child could not have inherited this property from my parents.
In 61, the Equal Wages Act was passed. That I think, even though employers found ways to bypass that, but at least because that law was there, later on, discriminated women could go to court.
But these attempts were rendered ineffective by rampant patriarchal bias. The laws left much to be desired, both in letter and in spirit.
Laws are never made to change society. Laws are made to maintain an existing social power structure. And if you make new laws, then you must make the necessary social changes that will make those laws practicable.
Law is an instrument of social change, but law alone is not good enough to bring about social change.
But just and fair application of law, too, has its requirements. It requires gender-just systems, an active watchful media, and a demand for and a knowledge of laws. For laws to be applied fairly, people had to know the laws. In the absence of a machinery to educate, laws for most remained complicated, confusing, and out of bounds.
A lawyer also doesn't know that how many laws there are. It's not possible. There are plethora of laws.
As it is, even if they knew how many of the laws they could implement in their lives because of other restraints, is a different thing. But they must at least know that they have such and such a law. So legal literacy is a big issue.
There has to be a machinery to educate. And this education can be done not by the government alone. There has to be other organizations, especially the organizations working with the people.
Apart from the Women's Commission, different women's organizations also try to carry this out. And nowadays, the legal aid system has also in it certain built-in programs for legal awareness.
Some of that responsibility was given to the watchdogs of civil societies. And how did they measure up to it?
It's the victim who's focused all the time. You have the victim being, this is the person who got raped. Her name is given in the papers. It's sensationalized. At the end of it, she's the one whose, copy is written on.
Journalists came and asked what is the name of the girl. Then we told them this is illegal to flash out in the paper name of the rape victim. Just flash out the accused name. Then it became popular that this is Sankol Maika rape case, at least one case.
The police stations, where the victim first goes and where the process of law really begins, are not always sensitive to women's plight.
On her own, a rural woman, a semi-literate or illiterate woman going to complain to a thana is just brushed aside.
We're having a major, major problem. That attitude is a major problem with the police.
Perhaps in recognition of the problem, attempts to change some of that attitude began to be made.
We are also member of a family. So we realize very much the problem of a woman or a lady.
In Lalbazar, all these women grievances and all, they have to take permission of senior officers like DCs and all before doing any action. So they are not that much free to take anything or any action they feel like. So they are also supervised. The supervision is very effective and they are being supervised closely. I think that is also making a difference.
ওখান থেকে চলে আসে এখানে ওখানে একটা কেস করলো কেন চলে আসে সেটা ওদের স্যাটিসফ্যাকশন কি আমি জানি না এটা হলো যে ভিকটিম তাদের স্যাটিসফ্যাকশন এখানে চলে সবাই ডিডিতে উইমেন্স গ্রিভেন্সের ডিডি এরাই ভালো কাজ করবে ওখানে গিয়ে আমরা ভালো কাজ পাবো এটাই ওদের স্যাটিসফ্যাকশন
We need specifically some officers who will be dealing exclusively with these problems so that when a lady goes to police station she is not turned back or she is not turned down.
Patriarchal bias, however, afflicted not just the implementers of law, it afflicted the interpreters too.
Look at the multiple cases of rape where the rapists are acquitted because of the entire structure of the judicial inquiry.
The initial adverse judgment on Mathura was that she was a woman of no standing. Therefore, it wasn't rape, it must have been consent.
The burden of the proof lies on the woman. And it's very difficult for a woman to prove that she did not consent, especially when in these situations there's hardly any witnesses. So, for example, a lot of rape cases go in favor of the rapist because these legal reforms have not been implemented.
The offence of adultery in the Indian Penal Code permits the husband to prosecute the paramour of his wife, but gives no corresponding right to the woman.
She's denied a right. She is denied a right to prosecute her husband. I mean, she becomes a victim of the adultery, she suffers it, but she cannot, she doesn't get any, she cannot get any redressal of her grievances. There's nobody to go to because the statute bars her.
This one-sided responsibility of the woman is also at times reflected in the family courts set up to improve women's status.
There is a general pressure on the woman, either to stay at home or to come out of the home. I mean, ultimately, again, in spite of having such a so-called favorable atmosphere, counselors, social welfare organizations, everybody, but she is not getting the true respite that the family courts should have given her.
Because they want to quickly dispose of cases, they want to push the women back to that situation that they were in. So they feel, okay, we've done so many cases in the year, but what's happened to the women?
While some complained about the quality of legal redress available, others bemoaned its absence.
আমরা যে লাইনে নামি সেটা তো আমরা শখের জন্য নামি না, আমাদের অভাবের জন্য নামি। সেটা তো আমাদের পয়সা আমাদের বাবা মা খাবে না, শুধু আমরা খাবো, মস্তান খাবে, মালকিন খাবে, পুলিশ খাবে, এটা তো হয় না। সেই জন্য ভাবছি যে আজকে যদি আমাদের একটা স্বশাসিত বোর্ড আমরা পাই, তা সেই স্বশাসিত বোর্ডের মাধ্যমে যারা সাবালিকা আছে যে তাদের নিজেদের পয়সা নিজেদের কাজে লাগাবে, আর আরেকটা যে নাবালিকা যে আসছে জোর করে যাকে লাইনে নামানো হচ্ছে তাকে মারধর করা হচ্ছে সেইটা আমরা বন্ধ করতে পারবো।
Despite the all-prevalent patriarchal bias, the late 70s did bring about significant changes. The civil society found champions of the women's cause among the women themselves. Rising violence against women and the growing evidence of atrocities against them inside urban educated homes became their first rallying point. Women's organizations began pressing for ways to empower women. Supported by many legal luminaries, their efforts brought about significant changes in law. To make this change possible on a continuous basis, women's organizations demanded the setting up of a machinery.
All India campaign had to be launched, and an All India protest day had to be threatened by the women's movement, collectively, all opinions in the women's movement, before the commission was formed. So actually, naturally, all the women's organizations consider it as a triumph.
Not to be left behind, sections of enlightened judiciary too hitched on to the bandwagon of change, and so did the press. However, as performance did not always match expectations, disillusionment set in.
We had a lot of hopes and expectations from them. We felt that they would be a strong arm that we would be able to use. And the reality is that actually they're not.
They started rushing here, the NGOs and even individual families, with cases of individual harassment, individual atrocities against women. This commission was not set up to go into individual cases.
If rampant patriarchal bias posed a fundamental threat to women's movement, then the rising tide of fundamentalism appeared to pose a far greater threat to women's status within the family and the community.
Talaq has to be enforceable in the Islamic countries. They cannot just say talaq and get away with it. What they can do here.
The ultimate tragedy that took place was the passing of the Muslim Women's Bill, which prevented a Muslim woman from the right to claim maintenance after divorce. And I think that was just a move to appease the minorities, and this was the political intervention.
What we found from the Shahbanu decision was that the government totally backtracked. Instead of going forward, it gave in to the fundamentalists and passed the Muslim women's protection of rights after divorce.
Fearing fundamentalist assertions, many began demanding for an egalitarian civil law that would ensure gender justice for women across all religions.
The proposed Uniform Civil Code focuses on uniformity between religions, but not uniformity between men and women. So what it would do in effect is erase the rich plurality of cultures that we have in India and still not guarantee gender justice. So the issue is not uniformity, the issue is gender justice.
No citizen should be deprived of its rights. I mean, if I'm a citizen of India, I might be a Hindu and I am entitled to monogamy and my Muslim counterpart is not. That is very wrong. So even the personal laws, if they are changed, it will boil down to the same thing. I mean, unless there is a concerted movement.
Concern for women's equality has often translated into demands for gender-just laws and their fair interpretation. But laws alone do not empower individuals to see and question the assumptions that threaten the very basis of the rule of law. Sex determination tests are banned, but sex determination still thrives. The act of sati and its glorification are a punishable offense, but glorification continues, though disguised. No doubt there have been attempts to change, but these are not enough. The more things have changed, the more they have remained the same.